Pascagoula, Mississippi on the 5th of July, 1945. My parents, my dad was from Pascagoula, and he worked for International Paper Company. My mother was from Pontotoc, Mississippi. And then my dad was transferred to the paper mill in Spring Hill, International Paper Company mill in Spring Hill. And we lived there until 1963. And at that, I graduated from high school in '63. I played football at Tulane. I got a scholarship. I was at LSU Law School beginning in the fall of 1967, and I graduated in 1970. When I was between my junior and senior years, I don't think they did this much, the law firms didn't, but anyway, Jones Walker came to the law school to recruit, and the person that was doing the recruiting was a guy named Andy Carrero, and Andy had gone to LSU Law School and was a lawyer at Jones Walker. And when I walked into the interview, he said, "Well, I guess you know something about our law firm, Jones Walker." And I'm sure this was the wrong thing to say, but it just, I kind of say what comes to my mind. And I said, "Well, actually, I don't know anything about Jones Walker," but I didn't know anything about any law firm. This was all new to me. Anyway, they offered me a job, and I worked there that summer, and I really liked it, and worked there for 2 years, and that was a really great experience. Mary went to Newcomb, and I met her when I was at Tulane. She was 2 years behind me, and we started dating when I was a senior and she was a sophomore, and we got married in January of 1970, and I had 1 semester left in law school. And then we lived in New Orleans for 2 years and then moved to Shreveport in July. I started at Jones at Cook Clark on my birthday, July 5, 1972. And
when were your children born?
Bill Richard was born in New Orleans in May of 1970, May 24, 1970. Our daughter Mackie was born in Shreveport, February 10, 1974. And our younger son David was born in Shreveport. So we have 1 grandchild who's pretty cute. When I first started practicing in state court, the cases that I handled a lot of them were automobile accidents. Aetna wrote commercial lines and personal lines, so you'd get homeowner type claims arising out of accidents around somebody's house, or occasionally you'd get an industrial accident. So I did a lot of work for Aetna. I did work for Maryland Casualty Company. They were here in Shreveport, but I did stuff for other people. But when I started out, those would be the main 2.
That you recall fondly and did in federal court?
Well, that was pretty easy to pick out one, because it was involving a claim against a lawyer who's a good friend. Well, two lawyers who are both good friends. One's back in town. This was, to sort of give you the background, Robert Piper and his partner Frank Brown represented a lot of claimants in civil rights cases. And this particular civil rights case, they filed against Roadway Express. The Roadway Express was an over-the-road hauler of goods. They were handling the case for the plaintiffs, and they had difficulty in communications, and I think the guy just sort of left them without any way of contacting him, and so they had trouble answering discovery, and Judge Dawkins dismissed the case against Roadway because of the failure to answer written interrogatories and document requests. So Roadway got the idea that they would, Roadway was sued a lot all over the country, and they were trying to do whatever they could to discourage lawsuits. So they filed a claim for attorney's fees, not only against the plaintiff in the civil rights case, but also against Robert and Frank individually. And this was $25,000 or so forth, which was a lot of money in those days. That their scheme was that under Title VII, the prevailing party may recover attorney's fees. So they combined that statute with 28 U.S.C. 1927, which at that time allowed the recovery of cost for vexatious conduct against not only the party but the party's lawyer. And so they said, okay, under Title VII, we're entitled to recover cost, which includes attorney's fees, and so we want cost, including attorney's fees, against Piper and Brown. The lawyer for Roadway was from Jackson, Mississippi, and his name was Curtis McKee. Judge Dawkins granted Roadway's claim and assessed attorney's fees not only against the client but also against Frank and Robert. So we appealed that to the Fifth Circuit. We argued that cost, 28 U.S.C. 1927 is penal in nature, should be strictly construed, and under the federal scheme, cost is defined and it's limited to what you paid to the clerk of court. Depositions used at the trial is very narrow. It certainly doesn't include attorney's fees. Fifth Circuit agreed with us, and I thought, this is over. We don't have to worry about this anymore. Well, Roadway filed a writ with the United States Supreme Court, and about this time, Warren Burger, who was the Chief Justice, had come out with a speech to the American Bar Association about how lawyers weren't doing a good job, and they were lawyers who were shouldn't be or should be penalized for their poor performance. The Supreme Court grants writs, and so there we are. Curtis McKee on the one hand and me on the other. We argue the case in the Supreme Court, and interestingly enough, they give you all kind of instructions when you go. If you don't have a vest on, well, you don't have to. In the old days, you had to wear a morning suit, which is like a cutaway, if you argued in the Supreme Court. Well, the rules had been relaxed by the time I got there, and they said if you don't have a vest, that when you stand to argue, be sure that your coat is buttoned. I mean, that was a big deal. If you didn't have your coat buttoned, the justices would ask you to button your coat, if you can believe that. They also said that at 12 o'clock, no matter what happens, they recess for lunch. And if you're in the middle of your argument, well, that's just tough, because you're going to be interrupted for lunch, and then you got to come back and pick it up. And that's what happened to us. Our argument was interrupted. The court at that time included Chief Justice Burger. Potter Stewart was on the court. Thurgood Marshall was on the court. And there was a book published about that time about the Supreme Court, which was the court as constituted then. Anyway, we argue the case, and the Supreme Court says, you're right, the Fifth Circuit's right, cost under 1927 is cost, doesn't include attorney's fees, but we hold that a judge may, in his authority to control his courtroom and control the lawyers in his courtroom, may assess fees and cost against the lawyer if the lawyer's conduct is in bad faith. Well, there'd never been a finding below that there was bad faith, so the Supreme Court remanded it to the district court to determine whether or not there was bad faith. By that time, Judge Dawkins had retired, and so it went to Judge Stagg. For whatever reason, Curtis McKee and Roadway Express took the position that they didn't have to prove anything, that the conduct of Piper and Brown was such that a fee should be awarded. Judge, we had a hearing. They didn't put on any evidence. And I said, they haven't proved bad faith. That's what the Supreme Court told them to do. Judge Dawkins agreed, and I ended up collecting my cost against Roadway Express. I've still got a copy of that check somewhere. When I came to Shreveport, it was, you got involved in the young lawyers section, and one of the things that you had to do was somebody had to be in charge of Law Day. Well, Law Day wasn't nearly as extravagant as it is now. And there was a file that was passed down from year to year, and you knew what to do by looking at the file. And Fred Sexton had started the file when he was in charge of Law Day. So that was one thing. I was president of the Young Lawyers section of the Shreveport Bar, and then later on I was fortunate enough to follow in the footsteps of David Klotz and Gordon Roundtree and be the president of the Shreveport Bar. And then my friend Henry Walker, he always got me involved in stuff, and he got me involved in the Bar Foundation, and I was fortunate enough to be the president of the Bar Foundation, which was really, a Bar Foundation does a lot of important things for the state. My plan is at 70, I'm going to quit trying cases and doing things like I do now. What I want to do, and I plan to do after 70, is I'm going to talk to people like Marty Stroud, and I'm going to learn how to do some criminal work, and I'm going to do criminal work, not trials, but working up cases and do indigent defender type stuff if somebody wants me to, because that's something that we need.